Hi everyone, my name is Heather Berg. I'm a lawyer in Nevada City, California. I practice cannabis-related law throughout the state of California, both criminal, constitutional, civil, regulatory, and pretty much everything else as it relates to cannabis. Our office does it. Our office is going to present a 4-part YouTube series, and this is part 1 of that 4-part series. The series will be called California Cannabis Law. Part 1 will focus on probable cause related issues or how to keep cops out of your property. Part 2 will focus on what happens if law enforcement does come into your property, which will be an analysis of state law, a little bit of ordinance law, and a bit of federal law. Part 3 will be how to prepare for the future, priority under MCRSA, the Medical Cannabis Regulation and Safety Act, and perhaps Prop 64. And then part 4 will be on cleaning up one's criminal record, how to get an expungement, get your old cannabis crime declared legally invalid, or have it resentenced and redesignated as a misdemeanor. I'm going to just jump right into it. I'm going to try to make this YouTube video about 15 minutes, so I may talk a little fast. I put my website up here. If you have questions, call the website or call the office. Check out the website. We have blogs. We have some other stuff on there, and you're always welcome to call and see if we can answer your questions in person. So hberklegal.com is us, and I'm not quite sure that you guys, I don't think the resolution on this is very good, but that's okay. So what is probable cause? Probable cause is what would lead a reasonable person to think that there's a fair probability that a crime is occurring in a certain place. That is the standard for probable cause to get into, to get a search warrant to get into a property. Many counties also have administrative codes that relate to their marijuana cultivation. And in that situation, in order to get an administrative warrant, the PC or the probable cause, the PC needs to be that there's a fair probability that there's an administrative violation occurring on the property. And why is that important? Probable cause, and PC is what I'm going to try to call it for short, is basically what is needed for law enforcement to get a warrant and to come onto the property. And so if somebody does have PC and they're giving out PC by the way that their cannabis is being cultivated, they are in a safety in numbers game in order to protect themselves from law enforcement coming in. What that means is a lot of people say, well, yes, I know that if a law enforcement spotted my garden from the air, they would have PC, but everyone around me is bigger, or they just don't have time to get to me. The safety in numbers defense is no defense. And safety numbers is not a good idea when it's your number that gets called. So what some people can do is take some reasonable steps in terms of how they set up their garden, and then just be aware of some of the main principles that may put them at a greater risk so that they can be more safe from detection in the first place, and secondarily from and mitigate any damages should law enforcement come onto the property. Okay, so I'm going to give you the basic probable cause equation, and there's 2 equations that I usually go by. The first is one automatic PC, so this is 1. This is my terrible drawing of a plant, and I know there's a little bit of a glare, but I think you can see. If there is just a plant that law enforcement's eyes can see, that equals automatically PC. And so if they can see it, if you are in a situation where you have a greenhouse, right, this is my terrible drawing of a greenhouse that I think is also made difficult by the glare, so you can see it a little bit more. If law enforcement cannot see anything, then we'll be in a different scenario, but if people roll up their sides and you can see the plant inside, or if they have a door, or if they don't have a door at all, or if they have a door that they keep open. All of these would put you into this first probable cause equation where plant equals PC. And so if that is your scenario, if you just have full season, full sun plants and they're detectable from the sky, then you are living in a safety in numbers type of scenario, which is not ideal. The second probable cause scenario is when you have your plant, but it is inside some structure. This could be a covered greenhouse, a barn. This is what would apply to indoor cultivators. Pretty much anybody where law enforcement can't spot it from the sky, be that a very close, when the tarp is on and the tarp all the way comes down if somebody is tarping their hoop, or in a greenhouse, in a barn, anything that's totally close. They need a +1 to get probable cause. So in order to get and I'm going to stand up from the glare again for a minute. And so we have scenario 1 and then we have scenario 2. Scenario 2 is where the plant is inside of this structure here. And then they're going to need a +1 in order to be able to get a warrant to come in. And so what we're going to talk about today is like what is a +1? And then what happens if you are in probable cause or PC equation 1. And so the main things that happen to get a +1 to give law enforcement probable cause to come onto the property is smell of cannabis, admission at the gate, that's a big one, prior contacts with these particular law enforcement officers, if they came to this property last year or in the last couple years, if you know the law enforcement from somewhere else in life, maybe from a prior arrest or something like that. That would certainly be something that would ratchet up the equation. If they believed that cannabis was inside, but they couldn't see it, or they couldn't really tell, they had no definitive information, a prior contact might be more like what I call a 0.5, depending on how similar it is to what they think that you're doing right now. Also, a true neighbor complaint, that would also not actually be a full +1. A true neighbor complaint would probably be closer to a 0.5, depending on who the neighbor is, how many times they've complained before, whether the law enforcement knows them, whether they have a criminal record. Essentially, any of the rules for sort of snitch testimony apply to neighbor complaints, and they have to be reliable. And so if they are reliable, then they probably would be able to get a search warrant based on that if there was also something that would substantiate what they were saying, like the greenhouse that in the law enforcement's training and experience might include cannabis plants and has in the past. So these are sort of things that, when we're dealing with PC issues and whether law enforcement can get a warrant, we're dealing in probabilities. These are sort of like maybes, and there's going to be quite a few give and takes. And so there are any number of scenarios that can equal this +1. And a true neighbor complaint, kind of depending on the circumstances, might. Another one is admission at the gate. I think I said that already. And repetitive gate notices. The repetitive gate notices are a big deal in many of the counties where we have strict per day per plant fines. And really in a lot of the counties where they have a more prohibitionist county policy towards their cannabis cultivation, most people have gates. And if you don't have a gate, you should definitely get a gate if you're cultivating cannabis. That is your first line of defense. And so what will happen a lot is that law enforcement will get maybe a true neighbor complaint, or maybe they'll spot a garden from an overflight. However they get there, sometimes it's just bad luck. They're swooping up the neighborhood. Sometimes they're just on sort of roving patrols, and they put these gate notices at every property where they think that there may be cannabis. And so what happens is that the first time law enforcement, if you're in probable cause equation 2, right, and they don't know that there's a plant on site, but they think it's there, and they're looking for that extra factor in order to get a warrant if they want to get it. Sometimes they'll come and do a knock and talk, right? So they'll come to the gate, that's as far as they can get, and they meet somebody there. And they say, hey, we want to come do an inspection. This is very common. And so a lot of times what people will say in that situation is they'll say, oh, it's just my medical, or it's, I only have a couple, and they're trying to downgrade the size of the cannabis garden, or sometimes they really just do have that small of a cannabis garden. Sometimes they are telling the truth, but a lot of times people are scared and they don't know what to say. And so oftentimes instead of saying nothing as they should, they will downplay whatever is going on. So if you get a law enforcement contact at a gate, do not consent. You do not have to consent. The law allows you, it gives you the power to say no if they don't have a warrant. And so that's the time you want to invoke that power in a kind and peaceful way. You would want to say something along the lines of, I'm sorry, I cannot give you consent, I'm uncomfortable, I need my lawyer present, I'm so sorry, this is not a good time. Can I get your contact information and call you back? Sometimes they will not let you do that, but most of the time they are going to let you do that. And if they don't let you do that, it probably means that they were going to, execute a search warrant on your property in the near future anyways. And so there's not much that asserting your right to silence and to not allowing a consent inspection at that time and moment. It is actually really helpful for you. It doesn't hurt. And so sometimes they'll say that they're going to go get a warrant, but most of the time, if you were kind and didn't give them consent, they were going to get it anyways. So you don't have to believe that hype. Okay, so repetitive gate notices, the last thing I want to say is that at some point people will get 2, 3, 4, 5, 6. What will happen in those situations is that at some point law enforcement, a judge would give them, most likely would give them a warrant to come in when there's repetitive gate notices. And they have what the law enforcement believes in their training and experience to be cannabis, and then they have 1, 2, 3, 4 gate notices. I find that problematic because there's still no definitive information that would show that cannabis is being cultivated there, besides the fact that it's happened in other times, and nobody's answered the question why. Or what's going on in there, we want to come see. So I find that problematic, but once you're getting into 3, 4, likelihood is that a judge would grant that, unfortunately. And they could come in, so then you're just playing in the safety and numbers game again. Okay, one thing I want to talk about is smell. And what happens a lot of times is that people know that cops have to get, law enforcement has to get that +1 in order to come onto the property. And so oftentimes what they'll do is they will swing the pendulum from having a massive patch that would be PC here. They'll rely on this, but they'll rely on this by having, 6 or 8 greenhouses. That is probably swinging the pendulum back so far that it could bite you in the ass. Once you get 6 or 8 greenhouses, even sometimes 3 or 4, law enforcement are going to find a way to get onto the property. And so, that is sort of going a little bit too far back the other way, in my opinion. But again, we're always dealing in probabilities. So I'm going to cross out equation number 2. And I'll just write it here smaller. So we talked about admission. When you don't say it's just medical or it's small or anything like that, where you say I'm not comfortable. We talk about repetitive gate notices. It's going to do a gate notice for time. We talked about prior contacts. And then let's talk a little bit more about smell, which historically has been one of the more important ways that law enforcement can gain probable cause for a search warrant. And so the rule in the past has been that smell of cannabis equals probable cause. That is a little bit, that rule is going to be tweaked by Prop 64, which I will go through a little bit more thoroughly in a moment. But for the most part, the smell of cannabis cultivating, of cannabis plants that are raw, that historically has been considered enough for probable cause for a warrant. And that happens a lot. Law enforcement would come onto a neighbor's property, or they would come onto the road, and then they would say, oh, we smell cannabis from the northeasterly direction, and that's the property over there. So then we did an overflight. We confirmed that they have a greenhouse. So between the two of those, we want a warrant, and the judge will usually say yes. That is going to be modified a bit by Prop 64, but for now, we're just going to presume that the smell of cannabis equals PC in this context. And then what happens is what some people will do is, let's say here's somebody's property, let's say it's 20 acres, and here's their home. And then put a big dark X on it so hopefully you guys can see it. Yes. Here's their home. And so what they'll do is, let's say here's the road. right? And so oftentimes, because this is where law enforcement can be, of course, instead of putting the garden closer to the road, they'll put it way out here in Timbuktu. And this would be, super far away from the house, just out in the kind of the middle and somewhere in their property. Well, what happens when you put this, the garden super far out so that they can't smell it is now you've also negated to some extent, and certainly reduced in any event, your right to be free from unreasonable search and seizure, which means that law enforcement doesn't need a warrant. And so what happens is that people will, put the garden way out here, not realizing that this area is what the law calls open fields. And this area near around the house, that is where the curtilage of the house is. And curtilage is spelled Curtilage. And I encourage you to Google the difference between curtilage and open fields so you can get a better understanding of what that law means. But just in summary, what it means is that the further you go away from the home, the less that the Fourth Amendment protects you. So the Fourth Amendment is designed to protect your home, your stuff, certainly you, your body, and your papers, your documents, your important papers. So, when you get out here, that's not really it's not your home, and it's not your stuff. It is land, but it's not really your effect, and which is the word of the Fourth Amendment. And so the law has held that in the past, that they don't have to have a warrant here. They can jump a fence if they want to. In the olden days, we used to see, not even in the olden days, but just in the past, 2 decades, we'd see camp rely on this property, campaign against marijuana planting, I think it was. I forget what camp stood for. And camp would come in and they'd just drop in from the helicopter chop and then they'd get back up. And the way that was legal, which was very arguable in the first place, but the way that they were doing that was based on this concept that there is no Fourth Amendment violation, so there's not much you can do because they're not really breaking the law. In 2012, there was a case called United States v. Jones, and then which said that even when you don't have a reasonable expectation of privacy, but you have a possessory interest in a certain piece of property, that not only if you have an interest in that property, a reasonable interest in privacy in that property, I should say, that they needed a warrant to get in there, but now also the long kind of dead theory of a technical trespass has been revived in the last few years. Still, it's hard to get that to cover property or a garden that's really far away, and that's a patch garden. It's different when we're talking about a greenhouse that's far away. It's different when we're talking about a barn or a structure or something like that. And so, if you do have a barn or a greenhouse, that would be an effect, right? That is something that would be covered. So if you have some kind of property here, barn, greenhouse, whatever, and you have taken steps to show that you consider that to be private, i.e. a privacy fence of some very secure type, not a ranch-style fence. The Supreme Court has said a ranch-style fence is insufficient to show that you want privacy. That is only to keep livestock out or keep livestock in. That is not to show the world that you have an expectation of privacy in this small area. So because if you put the garden all the way out here, that could be considered open field if it was a patch. If you cover it, now that becomes an effect. And so that would be another reason why you might want to look, a little bit more this year at probable cause scenario 2 or PC scenario 2, just because of the fact that even if it's very far away, which might help with some of the smell issues the further you get from here, if it's covered, you might have a little bit better of an expectation of privacy in there to keep cops out. Again, this is we're dealing in probabilities here. Anything can happen, but these are just some concepts to sort of be aware of. Another concept to be aware of is that if you put the garden somewhere that is sort of in the circle of where your home is, then they would need a warrant to go into the garden as well. And that also would shield you a little bit more from aerial photography, from law enforcement in the sky, and also for what we call aerial acrobatics, so helicopters that come too close, which we're also going to touch on in a minute. And so the helicopters that are coming too close, they can't, especially in the area around your home where you have that expectation to be private, you have a much greater degree of protection. And so these are just some concepts. There is no right, there is no wrong. It sort of depends on where the property is and what is, what are the different concerns about that property. So there's no right line rule, but the open fields versus curtilage is something that we have to talk about and people have to understand where they plan or plant their legal medical cannabis garden. Okay. And because a lot of times, if you have done so much work in the setting up of the garden, it's a real bummer if you set it up in a way that sort of invites law enforcement into your property. And I think it's an extra big deal right now, not because we want to avoid detection. That is not the issue anymore. Now that we have MCRSA, which is going to allow permitted commercial activity, and we see that some counties and some cities are allowing that. The point is not to be outlaws anymore. The point is to try to move towards reasonable regulation. But as we move out of the collective cooperative defense into MCRSA type permitting / regulation, permitting / licensing, it's probably going to be a bumpy road. And in counties like Nevada County, Yuba County, and some of our other surrounding counties here in the Sierra foothills, a lot of times the counties have very steep fines that add up real quick, and they can be assessed as a lien against the property. So in just sort of protecting that area that we expect privacy in, and kind of understanding that, and what rules are in play there, can help us really when we set things out to just understand what's happening. And anybody who is in PC number 1 equation, or anybody who is in PC number 2 but maybe doesn't have a gate, or their plants are in the open field or something like that, those kind of folks, you just need to do what I call a top to bottom sweep of your legal liability, and make sure that you have done your due diligence in your state law and in your local ordinance compliance, because you are basically inviting law enforcement on. So the people who are in that stage where they maybe don't want to, but they are by their conduct inviting law enforcement on because they're having a full season, full sun patch garden, those people, you better make sure that you have your paperwork posted, you know how to handle a warrant execution. If you are in that equation and you are therefore at risk, you better make sure you do 10 times as much work to make sure that you've mitigated any harm should law enforcement come onto the property. And we're going to talk about that in video 2. Which is going to be basically how to handle a warrant execution. So what are the laws that are in play? How do you comply with those laws? What does that even mean? What is law enforcement looking for? And so that will be in the next video. Okay, so we're at 20 minutes, so I'm going to just try to shut this down. Planting issues, things to think about where planting. Plant a patch versus a greenhouse. If you have a regular covered greenhouse, you are in a probable cause scenario 2, which is much harder to get you. If you're a patch, you're basically a sitting duck, particularly if you have a very large patch. A patch versus biodynamic or permaculture gardening. And so permaculture and biodynamic gardening, those methods of gardening are when plants are grown together in a symbiotic relationship, or plants are grown in with the sort of swells of the earth, like where they would naturally sort of rise and be. And so the benefit of those types of gardening is that you're not in a patch per se. And so sometimes when you think about how you look from the sky, and it might be a little bit harder to tell these cannabis plants from these tomato plants if they're being grown in some sort of biodynamic way, Or if your plants are being grown sort of in the swells and that's where trees are, they maybe aren't getting totally full sun for the entire season, but they might not be as easily identified from the sky. Multiple greenhouses. If you have a bunch of greenhouses, 3, 4, 5, 6, you are definitely closer to probable cause equation 1. Just because when you got that much plants, particularly when you're a county that has a $100 per plant per day fine, they're going to be looking for the people who most likely have the most plants, and a lot of greenhouses would indicate to them a lot of plant numbers, thus high fines, thus you would be somebody that they would want. So you, multiple greenhouse folks, would be low-hanging fruit for the sheriff when we get to the $100 per plant per day fines. Patch plus a greenhouse. Just don't do it. Pick one. If you have a patch plus a greenhouse and there's a bunch of plants in there, you're looking like you are going to have a high number of plants, plus you gave them your, you invited them in by having the patch. So yeah, pick one. Plus if you, have more sort of invested in the greenhouse, why invite them in by doing it outdoor? So this isn't, what I'm saying is always ideal. What I'm saying is that this year, when we have, particularly in Nevada County, these very strict, very punitive, heavy fines, people need to be doing a little bit better work when they think about, how they put their garden out this year. Okay, overflights. If you see somebody flying over you and you can read the number on that aircraft, write it down. Write down every single thing that you can remember about that. And if you have an established relationship with your lawyer, let your lawyer know. We can start to have a log of when they're overflying you. And sometimes they don't even know that we are clocking how many times that they come. So number one, write it down. Write it down, write it down. Especially the number, but if you can see there's 2 males or a male and a female or 1 male, you can say which treetop they came up to. Document how it made you feel, what were your senses, and how were your senses sort of engaged. So could you feel the dirt whipping up or the air whipping up into your face? Was it so close that you started to feel scared? At some point when they come really close, it's actually pretty scary. If you are in close proximity to that. So these are the things that we need to know. If it is that close, that is too close, it's totally inappropriate, and you need to let us know. Some people will advise that you call the FAA. This is definitely very strong medicine. If they are flying like that, particularly in an unsafe manner where they're flying over you, where you can feel them like very close and you're scared, that is way too close. The FAA will ground pilots who get that close, but you do have to identify who you are, where you were, and that you're complaining against this particular law enforcement pilot. So it's strong medicine, and most of the time it's not going to be something that you want to use unless you feel like they're harassing you. If so, you might want to check with your lawyer before you do so, particularly in light of the president-elect and how the FAA is a federal agency. We don't know. There's a lot of unknowns about our president-elect. If you do have a law enforcement contact, whether it's at the gate, whether it's in the air, whether it's anywhere else, but they are not on your property, I want you to take this moment to take stock of your state law compliance. Do not be a sitting duck for them. And if you are a sitting duck, or if you know they're on your radar, or if you know the roving eye of government has focused upon you, then you better make sure that if they do come on, that you have little to nothing to worry about because your state law game is on point. And what I mean by that is that you have done your due diligence in your state law paperwork. The days of having 199 plant script and 99, 12 footers in September that look like they're going to put out 8 to 9 pounds each, those days are kind of going by the wayside. And so it's time to do your due diligence and do that top-down check to see if you really are complying with state law. And because we have these new pathways that we can comply with state law, we should be trying. Make sure that you're at least doing something this year that you didn't do last year to sort of give good faith to these new laws that are coming. One of the main things that I think that people can do is that they can print out their best management practices manual from their respective water quality control boards. So for us in Nevada County and the surrounding counties, we're the Central Valley Water Quality and Control Board. They have, if you just Google water quality marijuana, the page will come up. There's also one for the North Coast. They were enacted a few months before us, and I'm not sure about the other ones, but they have a BMP as one of the about 5 or 6 different documents that they're going to ask people to know and to be permitted regarding when we can get local license, when and if we can get local licenses or local permits for cultivation related activities from our localities. And so what we can do now is that you can have that best management practices manual, and that you can make sure you've read it, you understand it, and that you're complying by it. So if law enforcement does come on, there is no environmental degradation, and the only reason that we don't have our water board waiver is but for the fact that the county won't give us a license to let the water board come in. But we need to be good actors now. And so part of that is understanding these issues. I have just 2 more brief points, and then I'm going to log off. Prop 64's effect on probable cause. Prop 64 added a piece to 11362.1 of the Health and Safety Code that says conduct that is deemed lawful by Prop 64 shall not constitute the basis for search. So the smell of 1 ounce of marijuana, of 6 growing plants, or of 8 ounces of concentrate is now no longer basis for a search. When there is an overwhelming smell, we're probably going to have to educate the law enforcement involved, the prosecution, and perhaps the court and the courts of appeal and the Supreme Court about that issue. I imagine that's going to be one of the issues about Prop 64 that is litigated, is what does that mean, conduct? How can you determine how much an ounce smells? We all know that sometimes that sticky, icky is super, super smelly and can smell more than hundreds of pounds if they're wrapped a particular way. So I think that issue is going to be one of the issues that needs to be worked out by the court. So we'll see. And I think I think that it's true. We can educate them that really sometimes a small amount of marijuana can be extremely odorous, and so we'll see how that one works out. But for now, it's the smell of that type of conduct that's legal, not the total smell of cannabis. And so we'll see how that shakes out when there's some kind of overwhelming smell that law enforcement is going to say is over what they think is appropriate under Prop 64. And then all of this, just knowing kind of where to plant the garden, what are the issues of probable cause, how do you handle law enforcement contact at the gate or in the sky, all of that kind of just comes down to maintaining the privacy and our expectation of privacy in what we're doing now. And so that on this bumpy road into reasonable regulations, that there are no hiccups for us or our family or for our teams. And so these are just things that you can know, but the goal is that even when and if law enforcement does come onto the property, that everything that you're doing is right and righteous. And so that's what we're going to get to next. This is just the first part of the analysis. And, if everybody's doing everything right, then who cares if and when they do come on, right? That's the goal someday, is that we want to be able to invite law enforcement on with their clipboard rather than with their guns. So that is where we're at today. Happy New Year. Today is January 1st. Please look for our next in our 3-part series or 4-part series that will be coming out probably in a week or 2. And so Happy New Year to everybody. Stay safe, and much love from Nevada County.